And when did you join the government?
When a new bureau was started to handle the everything but healthcare fraud against the government cases, I became the founding bureau chief of that bureau, which was called the Taxpayer Protection Bureau. The Sprint case, which ultimately settled for $330 million, although it took several years.
Indian reservations sell cigarettes without that label, correct?
That's correct.
Because they're exempt.
Right. Was a tax violation for buying expensive pieces of art and having them empty boxes shipped out of state. So it's really aimed at millionaires. They're not trying to go after, the person who hires the nanny off the books.
Okay, this is American Whistleblower. My name is Dr. Joe Piaccentile, and I'm with an old acquaintance, old friend of mine. His name is Randy Fox. He is a lawyer in New York with the firm of Kirby McInerney. Right, Randy? That's the name of the firm, Kirby McInerney. But I actually know you from your time at the Attorney General's office. That's how far back we go.
No.
But why don't we talk a little bit about you and your background, and then we can talk about the kind of cases you're working on now. When did this all start with you? You started out as an Attorney General, I believe, or?
Oh, no. I spent 16 years at Big Law before I changed sides. So, in fact, they're somewhat infamous firms that I was at because they merged and then went belly up after I left. I started off my legal career at Dewey Ballantine.
Okay.
And then in, I guess it was 1997, I moved over to LaBeouf Lamb, became a partner there. I was a partner for a number of years before changing sides and joining the government.
And when did you join the government?
So that was in 2007, fairly auspicious timing because it was before the two firms started talking about a merger, and which ultimately led to their collapse and a bit of a calamity there. But so I joined the New York Attorney General's office, first in the Medicaid Fraud Control Unit, which is where I met you. And then when a new bureau was started to handle the everything but healthcare fraud against the government cases, I became the founding bureau chief of that bureau, which was called the Taxpayer Protection Bureau.
Oh, tell me about that. What does that mean, Taxpayer Protection Bureau, and why did they form that bureau? It's an opportunity to talk, I guess, about the New York State False Claims Act as it pertains to taxes. Is that when all that started in 2011?
So the law adding tax was passed in 2010. The new bureau was started by the new Attorney General, who started at the beginning of 2011. And that was Eric Schneiderman. And he was actually in the state Senate before that and was the sponsor of the bill that added taxes to the New York False Claims Act.
No, that's very unusual, correct? I mean, normally when we think of false claims cases, we think of Medicaid, Medicare, federal Medicare, state Medicaid. Was New York at that time under Schneiderman, was that the first state to actually say that the collection of New York State taxes, that if you can bring a case showing New York State that they've been cheated out of taxes, could be sales tax, could be income tax, that was actionable under the false claim statute? Was that a one-off? Were they the only state at that time to add taxes?
So there were a few states that didn't bar tax claims, but none of them were active in the area. Just their acts didn't have the language that we see in the federal act and most state acts that say this shall not apply to tax violations. So New York passed this False Claims Act in 2007, and it was everything but tax. So it wasn't just healthcare. It wasn't just Medicaid, well, for state level, just Medicaid. Medicare is not state level. So it was any fraud committed against the government. It could be investment frauds or procurement frauds, et cetera, as well as healthcare frauds. In 2010, tax was added by the legislature, signed by the governor. In 2011, the new bureau was started to handle the everything but healthcare, but predominantly tax cases. at the New York AG's office. I'm not sure of the timing of Illinois' adding non-income tax claims to their False Claims Act. I can only guess that it was around the same time, but I don't have my finger on the date.
But it really was unusual of New York and very progressive thinking to say, let's collect taxes through the whistleblower apparatus. So let's allow New York State taxes, and I guess that was all taxes, correct? Income,
yes,
sales tax, any kind of tax that New York State collects. It opened up to the whistleblower population. Now, did you have any hand in that original legislation, the writing of that?
So I was not involved in adding that. I have friends who were, but my involvement outside of the healthcare realm really happened when I took over the Bureau.
So when you took over the Bureau in 2011, that was brand new. You were the first Bureau chief in that. They called it the Taxpayer Protection Bureau. Was that part of the Attorney General's office? That bureau reported to the Attorney General?
Correct. It was within the AG's office. The New York Attorney General's office has a number of protection bureaus. There's the Investor Protection Bureau, Consumer Protection Bureau. So this was the Taxpayer Protection Bureau because it was focused on taxpayer dollars.
So you pioneered that bureau.
Right.
But you were an assistant attorney general at that time.
Right.
Okay, great. So just so we know what this all was, because a lot of people out there who listen to these things, even the lawyers, they get confused as to were you an attorney general, were you not an attorney general? And so this was for anything New York State. And what type of state taxes were you focused on in the beginning? What were the buckets that you were identifying? Was income tax a big part of it? Was state income tax a big part of it? What was it?
Yeah, and the focus wasn't really narrowed by particular tax types. It was really based on can we find good cases? So I right off the bat, the Sprint case, which ultimately settled for $330 million, although it took several years, that was filed almost immediately after the Bureau started. I turned on the lights on March 17th of 2011, and I think the Sprint case came in on something like March 30th.
Wow. So right after, 2 weeks after you open the doors and turn on the lights, as you say, someone files a Sprint case. Can you tell us what the tax was exactly that Sprint was accused of not paying?
Sure. So that was a sales tax case. So it was both state and local, and frankly, an important piece of the tax puzzle under the New York False Claims Act is it's not just state taxes. It's also the local taxes that would include not just sales taxes, but real estate taxes, etc. So the Sprint case came in the door alleging that for the monthly plans that Sprint was selling in New York, you pay $29.99 for a cell phone plan per month, that Sprint was not charging sales taxes and, of course, not remitting sales taxes to the state when it sold those plans. And in fact, it was required to. And it was alleged that it knew that it was required to.
Who were they selling the plans to?
Just consumers, you and me, anybody who got a Sprint cell phone.
So anybody who had a Sprint cell phone was paying Sprint a monthly fee, $29. Sprint was required by New York State law to collect New York State, I guess, a sales tax on that, correct?
Correct.
And what was that tax amount, do you know?
So it was a combination of state and local tax. So like in New York City, it was 8.875%.
Okay.
In Ulster County, it would have been 8%.
Okay, so the city and state taxes that were attached to that fee, that service fee, were supposed to be collected by Sprint and then paid to the city and state governments, and they didn't do that.
Right, paid to the state. The state administers it for the localities, but that's...
All right, so they would pay it to the state. The state passes its portion along to the localities, Ulster County, Bronx County, wherever.
Exactly.
So did they collect the money from the phone users and just not pass it along, or did they just not collect it at all?
So they didn't collect it at all. Now, on one level, not a very bright scheme. because it's not really Sprint's money that they should be collecting and remitting. The reason, or at least I should talk in terms of allegations because it's settled, of course. The alleged reason was that Sprint saw that it could get a competitive benefit by undercharging Verizon and T-Mobile, and this is before mergers, by not charging the sales tax on these plans.
All right, so they could offer a less expensive plan. That begs the question, were the competitors, was Verizon, was T-Mobile, were they charging the sales tax and passing it along?
Yes.
So
And
they were
originally Sprint did it too, but then in their wisdom decided to change course and stop charging the sales tax.
All right, so Sprint had been charging the sales tax and passing it back to the state like it's supposed to.
Right.
And then at one point they just decided, hey, we're not going to do that anymore. And they thought that nobody would notice. Doesn't seem too,
So I mean,
too slick a program. I mean, that's not exactly.
Well, the allegation was that they saw that they could get a competitive advantage.
Okay, but
And
you
they
know,
changed course. And
I could get a competitive advantage if I'm a butcher, if I rob trucks and steal meat and then sell it to the public at a lesser price. That gives me a competitive advantage. That doesn't mean it's a smart move. So how does a company that visible, because this is a visible company, and you know, the competitors are always looking at each other's pricing, like almost every day.
Right.
So you would imagine that Verizon and T-Mobile and Sprint watch each other's backs and watch each other's pricing almost daily to see, you know, what the competition's doing. So at one point in their wisdom, somebody at Sprint decides, hey, let's just offer cheaper prices and let's not tell anybody. We'll just not collect New York State tax and not pass it along. So that'll lower the cost of a phone. It's got to lower it down for, you know, $6-7 a month, right?
math is probably about right. Yeah.
About right. So they do this, and you would think, I mean, I'm not a genius, but you would think that almost immediately somebody at Verizon and somebody at T-Mobile would figure it out and realize that their competitors just lower their price $6-7 a month. And the way that they did it was by not collecting income tax, state income tax. Was there a theory at Sprint that, I mean, was there any credible defense in their mind? Did they do it by saying, we don't really have to do it? So is there some glitch in the rule, or was there some innocuous wording or ambiguous wording in the statute that maybe made somebody on Sprint's team think that they don't have to collect it and that they were smarter than their competition? Was there any kind of like magic thinking like that? Because, you know, you see that a lot of times in fraud cases, right? There's magical thinking. We don't have to do it. We're not really committing a fraud. When you investigated this, what was their initial defense on all this, if you can talk about that?
Sure. So I probably can't talk about the things we saw in the documents they produced because that's probably still under a protective order. But I can certainly talk about the arguments that they made in court. And they took some of these arguments up to the state's highest court.
So what was the argument in court?
Their main argument was that the sales tax statute was ambiguous, largely depending on how they interpreted a comma in the statute.
Okay.
Personally, I would say it was not a good argument. It was never a good argument. And it was a completely after the fact argument. So, you know, Sprint did what it did for the purposes that it did it on day one. And then when it came to being sued and arguing against it, they said, oh, well, now that we look at it, this is really ambiguous because of that comma, and it must mean something other than what the state is now saying it means.
So they didn't get a legal opinion prior to lowering the price. They just did it, and then made an argument afterwards.
I don't think I can. I don't think I can answer that because of the protective.
Okay, well, all right, I get it, but
But actually, there was what
so they
came
took
out
it to
ultimately.
court. They didn't settle with you. They took it to court.
So they fought it for 8 years. They fought
8 years.
every little thing, tooth and nail. But one of the facts that did come out publicly, which I think was extremely interesting, is that it came out that when this particular sales tax statute was enacted,
Uh-huh.
Sprint engaged in lobbying for this law. And Sprint told the New York Tax Department, we understand that this provision means that we have to collect and remit the sales tax on these monthly plans.
Huh.
And a couple of years later, they do a 180 and ultimately argue, oh, we don't really have to pay the sales taxes on these monthly plans.
Why would you lobby for a law? Why would anybody lobby for a tax on themselves? I'm curious. What's the business decision?
I don't remember the specifics in that particular case, and that document came out after I left the office, so I didn't see it.
Seems odd, doesn't it seem odd?
What's that?
Doesn't it seem odd from a business point of view?
There were a lot of other provisions in that particular law, so this is just one of them.
So maybe that was a give back from them. They other things in the law they wanted. So one of the give backs would, and by the way, we'll pay some tax on this.
Perhaps I just
do all services, do all cell phone services like that? Also, let's stay with cell phone subscription services. They're all taxed. There's a sales tax on those. You have to pay tax on all that.
Yeah, at least in New York, yeah.
And how about other subscription services? Not for telephones, but like your Amazon bill or your television, Netflix, and all that. Are all of that taxed in the state of New York?
Most all of it is. There are some exceptions for internet services, or have been. But there were actually disputes about Amazon. They used to not charge sales taxes for shipments into New York as regularly as they do now. And in particular, there was a company years ago called Tiger Direct that really made its name for selling mostly electronics without sales taxes, which should give everybody pause. And it sounds great when you're a consumer if you don't have to pay taxes. But the fact of the matter is, you're as a legal matter, you're not really avoiding the taxes.
So they dragged this through the court for 8 years on some concept that the tax law is ambiguous.
Correct.
8 years for that? I mean, that just seems like a long time over a comma. I want their lawyers.
What I can say is between the time that the case was filed at the end of March of 2011 and when the state intervened, which was, I think, about 13 months later, after a full investigation, the state intervened and took over the lawsuit as an enforcement action, and then it became a litigation in court. And I left the office. It does seem like a long time to me, but I wasn't there day to day fighting the case at that point.
Could I ask what the ultimate settlement was?
Yeah, it was $330 million, which was full dollar for dollar what they should have paid under the False Claims Act. It's a treble damages statute. The damages to the state and the local governments was about $110 million.
Oh, so they trebled the damages then?
They paid full fare.
I got to tell you, let's talk about treble for a second. First off, that means to triple the damages. Second, it's built into statutes to punish companies that don't want to comply with the rules and drag you through an 8-year process. But I have to tell you, Randy, I've very rarely seen treble damages applied in the federal courts. It's there. I think U.S. attorneys have used it as a bargaining chip, saying, let's hammer out a settlement because if you don't and you drag this out, we could apply the treble damages theory, right? I mean, would you agree? I mean, treble damages are not really uniformly or routinely applied in federal false claim settlements. I just haven't seen them.
Well, there has to be an incentive to settle. And if you go to court and win fabulously, then the trebling is automatic.
Right.
It's
But
not discretionary to a judge.
it's usually used as a bargaining chip, a hammer over your head, saying if you don't settle, then we go to court, we win, we'll apply the treble damages. So they paid 3 times what they could have paid if they just written the check in the first place.
Yes, it was, I mean, at least from my perspective, a really bad choice to fight it the way they did.
Yeah, and how does the law firm then, I don't want to mention their names, but whoever defended them, whoever took this tact and then loses the trial, how do you look your client in the eye and say, but for us, you could have walked in with your checkbook open to the Attorney General's office, written a check for $110 million and be done with this. But we dragged you through 8 years of surus, which is a Yiddish word meaning, pain and suffering, right? Agita, it was the Italian of agita. I grew up in the Bronx, so we grew up speaking Yiddish, Italian, Spanish, a little bit of all, bits of Yiddish, right? So 8 years of surus, plus $220 million that we otherwise would have had to pay, plus the attorney's fees for 8 years. Attorney's fees for 8 years litigating against the state of New York have to be in the tens of millions of dollars at least, right?
Mm-hmm. So the AG's office tends not to seek its own attorney's fees, which I think is a mistake.
Well, not their own. I'm talking about just the defense fees.
Oh, their attorney's fees, but they also had to pay the whistleblowers' attorney's fees.
Right, the whistleblower's attorney's fees, and the whistleblower
were substantial.
What did the whistleblower got? What percentage in that case? Do you know?
It was 18 or 19%.
So they got 18 or 19% of $300 million. Not bad.
So not bad.
Who were they? Could I ask which firm was the whistleblower firm?
So David Koenigsberg was the whistleblower counsel.
Oh, from Levy, Phillips, and Koenigsberg?
No. Menz, Bonner, and
Koenigsberg.
Okay. There might be their name in there. Sorry, David.
Well, so as a message to future potential clients for you, some whistleblower waited 8 years and got $100 million. And then he shared that with his law firm. God bless America.
These cases are usually on a contingency fee. So
yeah, God bless America. That's the fascinating thing here. People think of, false claim, and they think of the drug cases, the big billion-dollar drug cases and all that. But what I'd like to do, particularly since this is what you do for a living, and I know you do a lot more now, but this is what you're known for. You were known for these big New York State tax cases. But am I correct that you do everything now? So you do federal false claims cases, you do SEC whistleblower cases, FinCEN whistleblower cases. I guess the new thing now is crypto whistleblower cases, right? Those are the new cutting edge things. We were doing Foreign Corrupt Practice Act cases until this new administration, right? The FCPA by executive order is not to be enforced, correct? I think that's what the executive order read.
Correct.
Yeah.
Although these cases can last a long time, and who knows what the next administration will do.
Yeah, but it really posed an interesting problem for cases that were currently in the system.
Yes.
I had a client in the Erickson settlement last year. That was like a $1 billion FCPA case. Now our client got paid, but we got in before Trump took office. So, and I'm just thinking, what happens to a case that's in the on year 4 of a 5 or 6 year cycle? Does it just get thrown out, or does it get suspended? And what happens legally on those cases?
Yeah. So those cases aren't actually cases in court.
Right.
So they're subject to whatever powers the administrative agency has. And if they want to terminate it, they have the power to terminate it. It's actually one of the benefits of the model of the False Claims Act over the administrative agency model, because it has protections against politics.
Right. So the agency can't be directed to just dismiss a case because it's in a court.
Right. Well, I think they sometimes try. But there's the safety valve that a whistleblower can proceed with a case on behalf of the government under the False Claims Act if
on
the
their
government
own
turns it down.
Yeah.
And that's a protection, not an absolute protection, but certainly a very big protection against.
Well, sometimes the
politics
government
interfering.
declines a case, but there are times the government dismisses a case.
Correct.
And that's the real death. That's a death sentence for a false claims case, correct? And the government dismisses the case over the objection of the whistleblower. And what can the whistleblower do in that case? If a government says we don't want to decline, we want to dismiss, you have the right to go to the judge and argue, correct?
Correct.
As a whistleblower?
Yeah. I mean, it can be decided by the judge. The judge will give a lot of leeway
to the government.
Yeah,
because it's not your claim. It's
the government's conclusion is reasonable and based on an investigation.
Yeah,
it's going to be extremely hard to overcome that.
Yeah. Try to explain to whistleblowers at the end of the day, it's not your claim. It belongs to the government. If they say that they want it dismissed, you're going to have to make. There are very few instances. I don't think I can remember one in the last 30 years where the government has moved to dismiss a false claims case and it didn't end up getting dismissed. Judges, like you said, they give deference to the government, and it's the government's case. So notwithstanding that, the rest of the False Claims Act under the new administration, all the SEC whistleblower rules, the FinCEN, it looks like it's getting expanded a little bit, actually. The government just came out recently. You want to talk about that? The government just came out recently and expanded some of the things that they're looking for. Is that pilot project of the Department of Justice. So, do you want to talk about that a little bit?
Sure. From the bigger picture perspective, especially when you're talking about the agency programs rather than the False Claims Act, legitimately, they can be molded to serve the priorities of whatever that administration is. And everybody can have lots of questions about whether they agree with those priorities or not, which isn't really part of my job, if you will. But I think it'll be a mixed bag because some of these programs are very consistent with what the Trump administration has stated its priorities are. And they want to limit fraud and abuse in healthcare, for example. And part of the Justice Department pilot program actually allows you bringing of whistleblower cases that go beyond just Medicare and Medicaid and the government healthcare programs, but can reward whistleblowers for bringing in claims that might affect private insurers, like United Healthcare or Aetna.
So you can bring a United Healthcare or Aetna claim to the Department of Justice under the new project that's under the new rules that were announced, I guess, a month ago or 6 weeks ago?
I mean, that was actually under rules that were announced maybe even a year ago now. So another administration. But that's still active, and they just announced expansion of that in certain
what did the expansion include? What did the expansion include? I wasn't aware, because if United Healthcare has been defrauded, typically those are just payer classes, right? Somebody will file a payer class action. But what's the Department of Justice's position now if you've got a healthcare fraud that involves these huge private payers like Optum or United, any of those big companies?
Yeah, well, one thing that'll be interesting to see is whether it's focused only or at least predominantly on criminal claims. Obviously, you and me as citizens can't bring a criminal claim against somebody.
Right.
But if there is a criminal claim against somebody for ripping off an insurance company, a whistleblower might be able to get a benefit
from a criminal claim.
They blow the whistle on that particular situation.
And that's new. That was never there in the past.
Right. So it's limited to forfeiture dollars. So the government would have to recover forfeiture from the
forfeiture dollars. Right.
Right. That's the only way they could really do it without getting legislation.
And the rest of it seemed to be focused on financial companies that were not yet public, because normally the SEC is for companies that are public or they borrow money in the public markets, the bond market and all that. But there are lots of companies that are pre-public that commit fraud on their they don't have shareholders yet. They're pre-IPO. They're about to do an IPO. I think the government now is allowing whistleblower cases on those type of entities as well.
Right. And again, my suspicion is it's predominantly going to be criminal cases.
Criminal cases, right?
So
That makes
It's going
sense.
to be run of the mill. Somebody screwed something up. It's going to have some serious intent requirements.
Yes, scienter. Let's talk a little bit about New York State taxes for a second, because I want to just go through the kinds of tax frauds that people can look for and bring to you in a firm like yours. I'm happy to talk about all the, a million types of federal cases, but I really would like, since your background was the New York State False Claims Act as it pertains to including New York State taxes, there are a lot of interesting and creative cases that could be brought that people just don't talk about. I'd like to, open that up a little bit, if that's okay with you. For example, that's one that I had always talked about, Indian reservations. They're exempt from New York State income tax when they sell, say, cigarettes and tobacco products, aren't they?
The sales taxes, yeah.
Sales taxes. And there was
and
a lot of...
They're excise taxes too. But
and what is an excise tax versus a sales tax?
It's just a tax on a specific kind of product.
Okay, so tobacco, cigarette, is that an excise tax or sales tax?
A little of both, actually.
Okay. So if I'm selling cigarettes on the corner of 42nd and 5th from my little shop, it's got a tax label on it, and I've paid, that proves that I've paid taxes on that pack of cigarettes. Indian reservations sell cigarettes without that label, correct?
That's correct.
Because they're exempt.
Right.
Right. And the scheme that I've always seen for years, and I was always meant to go after a case like this, was you'll take an Indian reservation in the state of New York, and it'll have 2,000 members, 2,000 residents living on the reservation, and they'll sell 20, 30,000 packs a day of cigarettes off the reservation. People show up with trucks, load up cigarettes at the reservation, and then vans, white vans, unmarked vans, then drive to the local neighborhoods in New York, all over the state, and sell these cigarettes out of the back of trucks. Now, that's tax-exempt sales. And I remember once, and I think it was Governor Cuomo when he was governor, actually wrote an article about it, gave an interview about this, that there was some estimated billions of dollars worth of New York State, I guess, income or excise taxes that were not being paid as a result of this. I guess it's a loophole, you would call it, that Indian reservations can sell this product.
Mm-hmm.
Now, does the law written for Indian reservations require that the cigarettes they sell are for use on the reservation only? Or did it anticipate that they would just be tax-free for their personal use? Or did it anticipate that they could be resellers of cigarettes and be tax exempt? You see my point?
Yeah, I think it's for sales by the reservation or by the tribe, or sales on the reservation or by the tribe.
For the tribe's use?
Broad, but
is it for the tribe's use only, or can they?
It's limited to that.
Okay.
But I mean, the questions you run into, some of the old cases have been about, is this really a Native American tribe? Because there are some sort of, let's say, non-traditional tribes out there. And other questions are about whether they're really being marketed and sold off the reservation as a sort of regular New York State commercial enterprise.
Okay, so you're saying, though, that if a legitimate Indian tribe wants to open up a purchase and retail operation where they're buying wholesale large numbers of cigarettes and then selling them to people who come to the reservation to pick them up, and then those people then drive out into the public, off the reservation and sell it, The Indian tribe itself is not responsible for that because they have this, I guess, treaty-based exemption. Is that what that?
Yeah. And frankly, it would be the same as driving to New Hampshire and buying a tax-free pack of cigarettes or a lower taxed pack of cigarettes and then driving back to New York.
Now, the people who are reselling them, though, in the vans in Brooklyn and the Bronx, when they resell those cigarettes, not for personal use, that's another sale under New York, and those people are liable to pay the tax, theoretically?
Yeah, so they should be paying the sales taxes, yes.
But they're not.
No. There have been estimates of something like 40% of the cigarettes sold in at least New York City are contraband.
These are contraband sales. And so the stores that sell those cigarettes, those small shops, they technically should be paying sales tax, but they're buying tax-free cigarettes from these middlemen who deliver all day long. And that's a big industry in New York. You're saying you think as much as 40%.
Right. And that's just, there have been articles that have said that. I have no personal basis.
Now, I always thought, though, my opinion, not yours, that the big companies, the Philip Morrises of the world, who are shipping to reservations, knowing that the reservations are reselling and knowing that that reselling is leading to tax evasion in a particular state. And let's stay with the state of New York. So if I'm Philip Morris and I'm delivering 1 million cigarettes a day to an Indian reservation, and I know they're not smoking it, I know they're reselling it, and I know that they have no liability to the state because they're allowed to resell it, but they're creating this black market of cigarettes where there is tremendous damage to the state of New York in terms of lost taxes. Is there a liability in theory for the mega tobacco company that's feeding this cascade of cigarettes, knowing that the end result is to damage the state that they're sending their cigarettes into? Is there a liability there?
So I think if I were doing an intake on a case like that, the question I would be asking myself is, what evidence do I have of the knowledge element?
So let's say, and that's a fair question. So let's say someone
is either actual knowledge, reckless disregard, or deliberate ignorance. So it's
let's say
absolutely knowing.
Or if someone came in, and it's theoretical. I don't have this case, so I'm not just being cute here. But I've always thought about it, but I've never had it. So let's say someone from Big Tobacco, whose responsibility it was to oversee sales into these reservations in a state, came in and said, yeah, we absolutely know that we're feeding this huge cascade of need and of sales. And we know that as a result of doing it through the Indian reservations, that the downstream are evading sales taxes, that we're feeding this black market knowingly. Would they then have a liability, in your opinion?
I'm going to have to give a lawyerly answer to that one.
Yeah, go ahead. That's what you are. We're both lawyers.
I'd really want to know what the internal discussion is, and what the thought process was of the company, and whether it was a sort of theoretical possibility versus something more concrete.
Is it possible, though, that the company would have a liability? Is it theoretically possible that the company, if they had really bad intent and you had evidence that the company had real intent, that this is what's going on, that they were aware and they knew it and they were happy to sell their cigarettes to these outlets because the outlets sell a lot of cigarettes? I mean, let's face it, if someone's selling cigarettes tax-free and then they're passing it downstream to people in vans who then sell it to bodegas and the bodegas sell it to the public, but there's a lot of cigarettes being sold, and that's a stream of revenue for the wholesaler, the manufacturer of the product. I could imagine a situation where they know that. Seems that everybody else in the state knows it, But no one's ever brought a case like that, I guess, because no one's ever come forward from Big Tobacco with enough evidence on a case like that.
Any case that's about an actor who's removed a step like that, you're going to want a higher level of proof.
Right. But I'm just saying, that's a theoretically possible case that's never been brought. But it's never been brought because there's never anybody's come in from that industry yet with high enough level of proof to make the case, but they're out there.
Theoretically,
Yeah.
I would
And the other cases too, weren't there cases involving jewelry stores, high ends, like the Tiffany's and people like that? Wasn't there a Tiffany's case where they were shipping boxes that people would buy in the store in Manhattan and then ship the box to New Jersey and then not pay sales tax in Manhattan on the case?
It's mostly been art gallery cases.
But haven't there been
There's a
jewelry
case against
cases?
Sotheby's about that.
But haven't there been jewelry cases in the past as well?
None that I've seen that are public, and I do track these cases pretty closely.
Okay.
A lot of them were under seal for a long time, so I don't necessarily know all of those. But the same concept applies in these art
But tell me
cases.
about the art cases then that you can talk about.
So, do you remember Dennis Kozlowski? He was the CEO.
Yes, the guy with the
Tyco.
golden Tyco, right?
Right, he had the $10,000 shower curtain.
He had
and the
shower
very
curtains
expensive French
and
clothes.
gold shower things. Yeah. So what happened with him?
So, one of the violations that he was criminally prosecuted for was a tax violation for buying expensive pieces of art and having them empty boxes shipped out of state while
Okay.
the artwork was actually delivered to his New York apartment, and then avoiding sales taxes because he pretended it was shipped out of state.
So he would buy a piece of art in the state of New York,
Right.
hang it in his New York City apartment. But in order to avoid New York City and state sales tax on that piece of art, he say, ship it to my home in Bedminster, New Jersey or something.
Right.
And then technically, if I ship, let's go look at the law first. If I buy an expensive piece of art in New York City, but I have a home in New Jersey and I have it shipped to my home in New Jersey,
Mhm.
I don't pay New York State sales tax on that, correct?
Correct.
I pay New Jersey. Do I have to pay
Probably have to pay
New
New
Jersey?
Jersey. That depends on New Jersey's law.
Right. But New Jersey, I either do pay tax or it would be a lesser tax or arguably than Manhattan's tax.
Yeah, I would imagine so, yeah. This is a sort of classic scheme. The Kozlowski's situation was not under the New York False Claims Act that predated the act, but it was a very famous example. Just recently, the New York Attorney General's office settled a case with Sotheby's, where Sotheby's was alleged to have helped a very rich art purchaser pretend that the art he was purchasing was for resale, but it was really just to be hung in his own apartment. And, if you're legitimately buying something to resell it, you can have a document called a resale certificate and legitimately avoid paying the sales taxes on something, because when you sell it to the ultimate consumer, then the sales tax will be charged.
Right. So resellers don't have to pay tax. So if I'm buying a piece of art to put it in my gallery for the purpose of reselling it,
Mhm.
when I buy it
That's
from
tax.
the first person and I put it in my gallery, I don't pay sales tax on it because technically it hasn't been sold yet. It's been repositioned for resale.
Exactly. You're just part of the chain of supply.
Right. So people will use phony resale certificates and they're really hanging it in their home.
Right.
Now, I do believe that there was a situation like that where jewelry stores would take an item, $1 million ring, and ship it to somebody's home in New Hampshire. You could, as a theory, buy a ring at Tiffany's in Manhattan for $1 million. But say I'm a resident of New Hampshire. I don't pay sales tax in New Hampshire, let's say. Ship it to my New Hampshire home. Now, if they ship it to your New Hampshire home, there is no sales tax to be paid because New Hampshire doesn't tax rings like that. If that was the case in New Hampshire. But if I was to ship an empty box to New Hampshire and wear the ring out, then the purchase happens in New York, and Tiffany's or whoever the seller was would have had to collect and then forward to the state the sales tax for it. Okay. So if routinely people in New York City, jewelry stores are selling high-end rings to people and jewelry to people, letting them wear the jewelry out the store, but then shipping empty boxes to states where these people say they live, where there is a much less or no tax at all, that's a violation that the seller, Tiffany's or whoever the store would be creating in theory.
Right. And there's a common thread to all of these situations is a lot of people's hands touch the situation. And if you've got a strong whistleblower law, any of those people can be a whistleblower.
Right. So
it's very hard to do these things in secret.
It never happens in secret. I was actually told, I don't want to say which store, but I was in a high-end jewelry store in New York City on Fifth Avenue. And the girl told me, she said, oh, we'll ship it to any state you want. We'll ship an empty box to any state you want. And this was after there was a case similar to that. Mm-hmm. And I said, they're still telling you to do that? Even she said, yeah, that's what I've been told, that if you want to send it somewhere, I'll send you an empty box. And I just laughed. And it was Christmas. I didn't feel like I didn't have my whistleblower hat on. I didn't, sometimes you walk in a room and you just want to have a good time and you're not paying, you don't want to, but there's a lot of it out there, right?
Yeah. Oh yeah. I mean, it doesn't take a lot of imagination to think there's an extraordinary amount of tax fraud going on. Some of it's penny ante, some of it's enormous.
Now, some of it's big. I'll tell you, there's another case. I want your opinion on this. There are tax breaks on certain kinds of federally funded housing that go into the state of New York. Mm-hmm. And I'm thinking of homes for artists, people in the arts. Mm-hmm. There's a whole bunch of apartment buildings in New York City that were funded with federal money set aside for the performing arts, people in the performing arts, or people with HIV when HIV was a big problem. And you would build, 500 units on 10th Avenue in New York City, but you would promise to earmark a certain percentage of those units, either for people in the arts or people with HIV. And there was a tax break associated with that. But then you would build your building, get your tax break, and not really rent out the appropriate amount of units to people with HIV or people in the arts. Now, that's tax fraud as well, isn't it? Well, that's HUD fraud, isn't it?
So, could be both. But, like everything else, I'd want to understand the knowledge element. It is true that sometimes people just screw up. And you need to be able to separate out the people who screw something up versus the people who knew the rules and did it anyway.
Right. And let me ask, that's an important question. I really want to discuss that. Let's assume it's construction. It's, apartment buildings. Mm-hmm. And let's assume that the apartment buildings don't have the requisite share of set-aside apartments that were required to benefit from the tax break that they benefited from. Right. The defense is going to be, we didn't know about it. Is that a defense? Is not knowing about a tax that should have been paid enough to get you off of the civil liability of paying? I understand why there's no criminal intent. You need criminal intent to charge a crime. Normally, you need intent, right? Right. Or recklessness or some crazy thing like that. But when we're talking about taxes, is intent a defense? Is lack of knowledge that you owed the tax, is that a defense to paying the tax?
Well, there's a difference between the requirement to pay the tax and to be on the hook for False Claims Act liability. So you absolutely have to pay the tax. And if you got audited by the tax department, they would say you have to pay the tax plus interest and probably with penalties. A False Claims Act case is really a fraud claim. It's not necessarily a tax claim in the traditional sense. So I would probably want to ask, is this a real developer? In most cases, it probably is. And they should really know. It's hard to imagine a situation where a real developer would not know those kinds of rules. Or is it some guy who wanted to invest some extra money in, building a 6-unit building and didn't really know what he was doing? he might have a better argument, but it's really hard to imagine that the real developer could not know that.
So I think it's important to I think you stated something that a lot of people need to be reminded of, even lawyers, that the False Claims Act, even the state act that says not paying state taxes would be collectible under the False Claims Act. In order for the person filing that False Claims Act to collect, you would have to show some level of knowledge and intent by the wrongdoers versus the state just doing an audit. You have no defense to the state of New York when you don't pay sales tax on something, or you get a benefit from the state, a tax break, and you didn't follow the guidelines for setting aside a certain number of apartments, whether that tax break came to you because you were putting apartments for people in the arts, or putting apartments that are just affordable apartments, or you were putting apartments aside for people with HIV or other types of diseases. And, whether you knew or didn't know, you didn't put the right number of apartments, you didn't qualify for the tax break, you get an audit and the state says you owe money because you didn't do what you were supposed to do. You owe the money to the state regardless of what you knew or didn't know. What you're saying is for the false claims cases, those are fraud statutes. And once you allege fraud, you have to show some intent to defraud.
Right.
That's the big difference.
Yeah. And the point here is really these the False Claims Act, at least the whistleblower laws, are really opening the opportunities for enforcement of government rules to ordinary citizens. And it's only open a certain degree. It's not letting you be the government in every way, shape, and form. It's just in the specific situation that I guess the legislature deemed so important when people are really actively defrauding, that it makes sense to take advantage of that extra enforcement.
It was set up to catch bad actors.
Yep.
Fraudulent actors, people with intent to evade these taxes.
Right. And
so give me another example.
Even there's a dollar threshold for the New York tax claims under the False Claims Act.
What is the dollar threshold in New York?
So it's twofold, really. So the damages in the case, you have to claim that the damages are more than $350,000.
Okay.
And the defendants each need to have had net income or sales of more than $1 million in any tax year at issue. So it's really aimed at millionaires. They're not trying to go after, the person who hires the nanny off the books, or
they're not going after the bodega that's selling cigarettes without tax stamps on them. They're going after fraudulent actors who owe more than $350,000 in the tax year and have earned more than $1 million in the tax year in question.
So the 350 is the overall claim, so it might have been over multiple years, but
okay,
you got to be a millionaire, basically.
The claim has to be over 350 or more, and the person has to have made over $1 million in the during the tax years alleged. Okay, so give me so with that in mind, tell me about some of your more successful cases that you've personally handled and settled that we can talk about.
Sure.
Things that you've done.
So one that's in the public realm is a case against a hedge fund billionaire named Thomas Sandell.
What was that last name?
Sandell, Sandell.
All right. So Thomas Sandell was a hedge fund billionaire living in New York State?
For part of the time, but he had actually moved to London.
Okay.
The primary issue was about the business, not the individual. And so in 2017, there was a provision in the tax law that said he had to recognize income that had been deferred years earlier. So in 2017, he had, I think it was about $475 million of income that he had to recognize under federal tax law. And then the question is, well, does the state get to tax that money? And the provision under the tax law in New York State was if the services resulting in the generation of that money, which was actually years earlier, happened in New York, New York gets to tax that $475 million. So after the services are performed, after the money is earned, just not recognized and taxable, Sandell pretends to move his company to Florida. He opens a 3-person office in Boca Raton.
Okay.
But he keeps his main office on Madison Avenue in Manhattan. And that's where the CFO is, and that's where almost all the operations are done. But come tax time, it's like, we're from Boca, leave us alone. And so this is a whistleblower case where I represented the whistleblower, and we filed it with the New York AG's office. They did a great job in investigating it, and it resulted in a settlement of $105 million. So for income taxes, that's the largest New York settlement there is. The Sprint case was sales tax, that was bigger. And this is a classic situation, the residency type issue where somebody pretends not to be in New York. There's even been another couple of cases involving hedge funders who pretended to be in Alabama and not in New York, and they had to pay, I think it was $70 million.
And the real issue here is he had 2 offices that, in this case, one in New York, one in Florida. His argument was that the money was earned from Florida. But if you look at the people living in Florida, working in Florida, and the people working and living in New York, the state's going to say, well, look, you have a disproportionate.
Mhm.
What if it was what if he had only claimed, instead of saying all this money was earned in Florida, what if he had said a portion was earned in Florida and a portion was earned in New York, and the portion was, say, broken up according to the amount of people and the efforts based in New York and Florida? Would he have been more correct to then say a portion of my money was made in New York and a portion made in Florida? And then
If the Boca Raton office had existed back when the services were performed,
right, exactly,
it did not. But if
okay,
it
but
had,
if it did, yeah,
that would be a legitimate argument. But of course, they had 50 people in New York and 3 people in Florida, so it wouldn't have been a very big allocation.
right. So you're saying that if a company or an entity, and in this case a hedge fund, earns money in certain years, and the state is going to look at where you actually earn the money.
Mhm.
And if you're going to say that this money was earned in a different jurisdiction, you have to have a good faith basis for saying that money was earned in a different jurisdiction. You can't just open up a mailbox in another jurisdiction. You're saying in this case, he had no operation at all in Florida, or he did have some?
At the time that the services were performed, which was years earlier,
Right.
the Florida office did not exist.
Okay, so he tried to claim Florida earnings for an office that didn't, at the time when he had no presence in Florida.
Right.
Yeah, that's kind of,
It's kind of audacious.
yes, audacious.
You see a lot of audacious residency schemes.
Okay, now what about bigger companies that, have 2 offices? They have a New York office with 1,000 employees, and they'll have an office, say, in the Bahamas with 5 employees, but they claim the bulk of their earnings from the Bahamas and say that it's but should be taxed at a Bahamas rate. A company like that would be liable, wouldn't it?
So I think New York has some very particular allocation rules about when the count income is New York income versus somewhere else. It's a source income rule. And these days, it changed a lot in 2015, but you know what, the weeds on that. These days, it's mostly about where the customers are if you're making sales.
Okay,
So companies have to track where the customers are, and sometimes they lie.
well, when did the New York allocation rules change? In 2015?
Right.
But prior to that?
Prior to that, it was a complicated mess.
Okay, so prior to
where they owned
2015,
property, where the employees were, and where the sales were made. And you sort of mix up percentages under certain rules.
all right, so part of this was the rules were muddled prior to 2015. So since 2015, and what is the statute of limitations on New York State tax fraud, by the way?
So Under the False Claims Act, it's a 10-year statute of limitations.
Okay. 10 years look back.
Right.
How about from the state of New York itself?
Pretty generous.
How about the state itself without New York, without the False Claims Act?
So if it's a criminal case, it's probably 5 years. I'm not sure about that. There can also be cases for civil fraud. There's actually no statute of limitations for civil fraud. Civil tax fraud, I should add.
So it's 10 years for this False Claims Act.
Right.
So we're in 2025. So anything that you would bring right now as a New York State false claims tax case would be subject to the new 2014 rules. So can we just discuss what those rules are? Because you say that everything got better, I'm guessing, clearer, less muddled in 2015?
Simpler. Yeah.
Simpler. So what is the tax? How do we figure out taxes from the 2015 rule now? It hasn't changed since 2015. It's pretty much the same?
Not materially. So,
okay,
generally, the allocation, if it's a company that's selling a product, is going to be based on where the customer is.
Okay, so if I'm selling a product like a service, a subscription service, let's say a financial subscription service, and there's 100 of them out there, right? It's where the subscribers live. So if I have a subscription service that's selling subscriptions to subscribers in 50 states, I would pay the income tax in that state, correct? Not where I'm based.
Right.
Okay, so if I have
the rules of that state, of course.
So if I have a New York State financial company and I'm selling a service, a subscription service, and I'm selling it in 50 states, but I'm based in New York, but I'm, say, 20% of my subscribers are in New York State, I would only pay New York State sales tax on that 20%. And then I would have to go, when I pay taxes, I would have to file tax returns in 50 states, correct? And pay 50 states those taxes.
There's certain thresholds in a lot of states, so you might not have to. But a lot of companies that probably have to pay taxes in a lot of places.
Okay, so those companies pay taxes in a lot of places. It's sort of like baseball players, I think, right? Baseball players have to pay income tax in the different states that they play baseball.
Oh, I guess that's probably true. I hadn't thought about that. Yeah.
Yeah, when you get these big mega players and they move to Florida and they're Florida residents, but the states will say, look, you're a New York Yankee and you play half of your games here in New York. You've earned your money in New York. And then we have your schedule and you play, this is every stadium you played at. So, I mean, I believe this happened with baseball players. A lot of baseball players moved to Florida, low income states, because it's beautiful and they train in Florida. They do spring training in Florida, but they earn their money, the ticket sales, at least that portion when they're playing in public, that happens on a schedule that everybody in America has a copy of. So all of those states can claim a piece of that revenue. I think baseball players have to file in 50 states.
That may be.
Makes sense, right? Doesn't that make sense?
Yeah, it's full employment for accountants.
Yeah, no kidding. So what other kinds of cases in New York have you been involved in that, we could tell people about? Because, there's whatever amount of fraud that you've uncovered for New York State income taxes, we'll agree that it's the tip of the iceberg, right?
Yeah. I mean, boiled down to its simplest, most cases are about people either lying about their revenue or lying about their expenses or their deductions. And there are hundreds or thousands or millions of ways to do each of those.
But don't they also lie about their locations?
Yeah, and that's a form of lying about their revenues.
So if you're a lawyer,
revenues are from New Jersey and not from New York.
Because I know a lot of lawyers that live in New Hampshire now, have second homes in New Hampshire, second homes in Florida. And if you have a New York office, a Florida office, or a New Hampshire office, how do you report accurately? What are you supposed to do? And let's say you're making, $3 million a year and you're living in 3 states. You have a home in New York City, a home in New Hampshire, and a home in Florida. That's a very common story. And you're making $3 million a year. How do you report your state income tax? You were supposed to report this by the days in every state. I mean, how does that work?
Yeah, ideally you should be keeping track of that, and I'm sure there are accountants out there that will beat their clients over the head to make sure that they're keeping track of those things. Some even have apps which track you with GPS.
Right. So if you're traveling around and you have a law practice and your clients are everywhere, but you're at home in Florida making phone calls, you're at home in New Hampshire making phone calls, arguably you're creating that revenue for yourself from your home in Florida, from your home in New Hampshire.
Right. Oh, it gets even more complicated, though. If you're an equity partner for a firm that has multiple offices,
yeah, what happens to that?
You're going to file in a lot of states.
So if you're an equity partner that has offices in New York, California, but you also live in Florida and New Hampshire, you're getting equity, you're getting income from what you're earning, but you're also getting income from what the firm is earning in those jurisdictions.
Right.
And therein lies the problem, correct?
Yeah. And a lot of firms do sort of group filings for their partners, usually for states other than New York and California, which are particularly high taxing states.
What is a group filing? What is that?
Basically, the firm takes care of the accounting to make sure that things are filed in
properly,
Wisconsin or Iowa or wherever else the firm might have earnings and have tax.
And the firm tracks all that.
So
where are the big fraud centers that you see? What do you think is unconquered territory for you and your practice? Mm-hmm. What kind of cases are your bread and butter cases that you're looking for?
So it's not so much about the type of tax. It's about the egregiousness of the conduct. If somebody has really thumbed their nose at the tax rules, that is the most promising kind of case, especially if it's big dollar value. There are I spent a lot of time in the last couple of years talking to state legislators and state attorneys generals, essentially spreading the message that they are leaving a lot of money on the table for their taxpayers. And it's really a disservice to their citizens not to have tax whistleblower opportunities, because they're not going to find out about a lot of tax frauds that are really causing the state to have fewer dollars to put teachers in schools and cops on the street. And it should be a real political deficit for anybody who doesn't let that happen. California just had a recent effort to pass a tax provision for its False Claims Act, and it's been stymied, at least for the time being. I think it seems largely because corporate interests are incorrectly describing the history of tax whistleblower provisions out there, particularly the New York one. And largely the argument has been, oh, well, everybody's just well-meaning and trying to pay taxes, but it's all just so darn complicated. And the history of New York cases is not that at all. The Chamber of Commerce put in an amicus brief in the Sprint case in the highest court in New York, saying, oh, Sprint was just acting in good faith to try to comply with such complicated legal rules. And the evidence about Sprint having lobbied and said exactly what they understood the law to mean hadn't come out yet. So you have these people submitting briefs, making these completely unfounded statements as if it was gospel, because they want to convey that every taxpayer is well-meaning. Now, you and I think anybody listening to this knows that there is tax fraud out there, and quite a lot of it. So it's very hard to say as a blanket statement, everybody's just well-meaning. It's also very hard to say that every tax rule is just so darn complicated and full of gray areas. If you have
That's just not true.
Books and one is real and one isn't, and you're using the one that isn't for your tax preparation, I don't see a lot of gray areas there.
So really, it's not so much about the type of tax, it's about the egregious conduct and the amount of money involved. So you're looking for cases that are, so these cases can be corporate tax, bad actors, right? A corporation that just decides, the way Sprint did, we're just not going to collect New York State tax because we can offer a cheaper, more competitive price to our consumers and we can sell more phone services, right? And how they didn't expect to get caught is kind of, that's what I don't understand. How can you sell
You act
millions
with
of
young.
phones? I just don't get that, and um, then that ranges all the way to the people who use reseller certificates and abuse that process.
Mhm.
So they're buying artwork, they're buying expensive jewelry, and they say, I have a jewelry shop in Connecticut, but really they're wearing it on their fingers. Or they have an art shop in New Hampshire, but really they're putting it in their New York City apartment, and people who do that kind of thing.
Mm.
Or the jewelry stores who routinely ship empty boxes. I mean, routinely shipping empty boxes should be should be a red flag for any business that's selling expensive products, right?
And then it would be whistleblower, yes.
Yeah, there was an interesting one I saw where it was an appliance store and a chain of appliance stores. And they had decided, and I didn't realize this at the time, that when you buy um, a microwave oven or you buy a refrigerator, and some of these refrigerators are $5,000-$10,000 a piece. If the refrigerator was sold or the oven as a built-in, that was going to be built into your house. Tell me if I'm wrong about this. That was tax exempt, sales tax exempt, because it was going to be part of the structure of your home.
It's capital improvement.
Capital improvement, right? But if I was going to sell you a standalone refrigerator or a standalone microwave oven, that's an appliance, a standalone appliance, not a capital improvement to your home, that was taxable.
Yeah. So when you sell your home,
Right.
the built-in is definitely going to be part of the home.
Right.
So you'll get your gain from that when you sell your home.
And you'll pay a capital gain tax on that.
It might have
Right.
depreciated, but that's the theory.
So the theory is that's a capital gain, something that is built into your home. But this particular appliance chain was selling appliances and giving receipts that they were built-in appliances when in fact they were not built-in appliances. So they didn't charge sales tax, didn't collect it, so they could sell refrigerators and microwave ovens cheaper than they could, than the competition could. And that would be a tax fraud, correct?
That certainly sounds like one. I thought you were going to describe one of the earliest settlements that the New York Attorney General's office had when I was there.
What was that?
Case, which was against a New Jersey appliance seller that was delivering and installing appliances in New York and essentially advertising, come buy your appliances here, it'll be tax-free. But because they were actually delivering and installing in New York City, they had to pay the New York sales taxes, and they didn't.
Yeah, no, the one I was talking about, they were taking advantage of the capital improvement tax advantage, tax break. But those are still out there. People are still doing it. People are still shipping. Sure. Jewelry stores are shipping empty boxes. I'm sure art dealers are still doing this. And it's hard to catch, particularly when it's art dealers, right? Because unless somebody involved in that scheme comes forward, how would the state ever find out?
Yep.
Yeah.
I mean, but just think about all those people who have to touch it, who could be whistleblowers when there's an effective whistleblower law. And you have to give an incentive to let people take on that risk.
So you're saying that what your practice is built on is really any large transaction where there was intent to defraud the state from a tax. And it could be any tax, an income tax, a sales tax, any kind of an excise tax, for example.
Yeah. So the kinds of things I'm going to be asking somebody who calls me up and says, I've got a case. Are some obvious ones, like how much is at issue. But so what rule was violated? How do you know it? And what's the evidence, or what can an investigator find as the evidence that will show that they did it this way and not that way? Because ultimately, and of course, I want to know, what do you know about why this company did it? Did they have intent? Um, Ultimately, you want to present to the government, in the best case, something in a nice box with a ribbon wrapped around it that says, here's the case and how to prove it. Not every case is quite that perfect, but you definitely want to be able to give the government the tools to come to a winning result.
And the accountant on the case, somebody does accounting for and is directed by the bad guy to, I'm not reporting this. I want to report this income as though I live in Florida, not New York. And the accountant does it.
Mm-hmm.
Can that accountant be a whistleblower as well?
Yeah. Now,
does he share a liability is my point.
I would be asking whether they came up with the idea or whether it was forced on them.
Yeah, most times.
If the boss comes in and says, do this or you're fired, that's easy.
All right. So, and there was a case, I believe, years ago about some brothers in Long Island that were in the cell phone business, some mega case that settled, and it had to do with something like that. And the accountant was told, if you don't do this, you're fired.
Mm-hmm.
And he did it and then immediately filed a whistleblower case because he wanted to protect himself more than anything.
Mm-hmm.
And that could be another reason. There's a lot of people out there, well-intentioned accountants who've worked with companies for years and then are sort of given this choice, right? That if they don't go along with the family scheme, and these are usually wealthy families, that their job is at risk. But yet they feel they're committing a crime, and the only way that they can protect themselves. Now, when somebody comes in and does that, and you take them as a client and you walk them into the Attorney General's office, do you actually discuss an immunity, an immunity deal for that client in advance, just on the chance that you don't want the AG, you don't want to walk your client into the Attorney General? And how do you protect your client's criminal liability in that case as a whistleblower?
Yeah, you definitely want to explore all the facts ahead of time and certainly make sure the client is aware of all the potential downsides.
Right, but can you get with the Attorney General's office, for example, an agreement that your client won't be prosecuted?
So it's almost unheard of to get full immunity, but they will often give out a what they call queen for a day immunity, which
Can
basically
you queen for a day, because that's where I was leading with this, but it would be great if you can explain what that is.
So, and basically it says that the prosecutors are not going to use the information that you provide on the day of that agreement to prosecute you.
Right.
It doesn't mean that the prosecutors can't get other information or even the fruits of the information that you give them to use to prosecute you if they want to. As a general matter, and this all is going to depend on the facts, of course, the prosecutors aren't really going to want to go after somebody who is coming in, providing them with good information, who wasn't deeply involved in the scheme. But there's always some exposure, and it really has to be weighed on the facts of that particular.
Right, and it's not in the interest of an attorney general to try to punish well-intentioned whistleblowers who come forward. I mean, that's where the information comes from. Mm-hmm. And it's hard, if you want really good information that speaks to the intent of the wrongdoer, that means you're going to be speaking to accountants, trusted individuals, higher ups at the company, executives at the company. And those people always have some measure of exposure, giving them a queen for a day. And it's just not in the interest, would you agree, of the Attorney General's office to go after these people. That would shut off the flow of information that these whistleblower cases depend on.
Yeah, I think it would have to be a very extreme circumstance for them to come to a different conclusion. Maybe somebody trying to hide their own involvement this way.
Right. And you are known in the industry as the go-to guy for all these type of cases, particularly these New York State tax cases, because you've been doing this forever. I mean, you're probably the most experienced lawyer in the New York area with New York State tax code whistleblower cases. Wouldn't that be correct?
I actually brought the first New York False Claims Act case that was initiated by the government when I was in the AG's office.
Wow.
It was
So
a pharma case against Merck.
tell me about that case.
So Merck had a drug called Vioxx. It was a pain drug, and it had some very, shall we say, unfortunate side effects like heart attacks. And the way they did their scientific studies and marketing was, shall we say, questionable. And there was a whole lot of litigation against Merck about this. So New York brought a False Claims Act case against Merck and ultimately recovered, as part of a multi-state settlement, which was hundreds of millions of dollars. So New York got about, I think it was 90 million. I have to remember those numbers, for its Medicaid program. So that was a result of my and others, of course, handiwork.
All right. So you were involved in the Vioxx civil settlement for the state of New York.
Right.
Yeah, I'm looking. That was back in,
Oh, wow.
oh my gosh, 2011.
12?
Yeah, the civil settlements. There was a lot. And was Vioxx eventually pulled off the market, I think?
Vioxx, it was actually.
That was
There's another COX inhibitor that's still on the market.
There was a Seeger Weiss served as co-counsel on a Vioxx products liability case involving
Right, that was for private plaintiffs, yeah.
27,000 private plaintiffs, and that was a huge settlement. That was a $4.85 billion settlement with Merck.
Right.
Never stops with the drug industry, right? The gift that keeps on giving to the legal profession anyway.
Look, pharmaceutical companies sometimes make some great drugs and sometimes do some bad things.
They certainly do. And that's sort of where my perspective is. And look, I love the pharmaceutical industry. I think we have the best one in the world. I just think that we have a system that needs overhauling. We make the best drugs. We have the best physicians. We have a healthcare system, in my opinion only, that needs dramatic overhauling. It's like I always use the analogy that if you're in Italy and you're in a coffee shop and they make really good coffee and you're feeling generous and you want to buy everybody in the coffee shop a cup of coffee because everybody's entitled. It's a human right, as Bernie Sanders says, to have a good cup of coffee. So you want to pay and you want to buy everybody in this cafe in this cafe a cup of coffee, but coffee in this coffee shop is $5,000 a cup. That's the American healthcare system. I think we have the best in the world. I do think it's a right and everybody's entitled to it. I just think it's way overpriced, and the coffee's $5,000 a cup, and it shouldn't be. Coffee should be $1 a cup. And until we fix that problem, it's not going to get better. And people like you and me, we work our little magic to make it better in small places. Hits the here and there, but it really does need a major overhaul from the top down. Good people, well-intentioned, but it's $5,000 a cup. And that's a problem.
People like me are in the enforcement business. It's not so much the policy business.
No, I know that.
Lots of policy that could be
Although
revisited.
I wouldn't mind if I saw you in the policy side of it. I think you'd make an excellent policy person.
I have plenty of ideas that I don't make a living on policy.
Did you ever consider running for office? I mean, you've been at the Attorney General's office. You've done so many different jobs. At this point of your life, why not run for something? Did you ever think of that?
I'm happy with what I'm doing.
Okay. You never know. All right. Well, that was Randy Fox.
Politics is an interesting sport these days.
Yeah, well, you're right, Randy. And maybe it's not for us. Randall Fox, or Randy Fox as I know him, thank you so much You're at Kirby McIntyre in New York.
McInerney, yep.
McInerney. And do you want to give your email address or your website, perhaps?
Sure. So my email is rfox@kmllp.com.
Oh, that's easy. rfox@km,
so Kirby McInerney.
kmllp.com.
And
Perfect.
the website is www.kmllp.com.
Simple and efficient. Well, Randy, listen, you have yourself a wonderful day. Thank you very much for coming on, and look forward to seeing you again.
Yep. Pleasure to speak with you.
All right. Bye-bye, buddy.
Take care.